It is not just mere delivering lecture, it is interactive session. I take note of your any doubts and all. Then we'll discuss either in the final timings or tomorrow. So now over to the presentation. So we discuss about the legal system. Why the law is important? The question arises. Why the law? If you many of you maybe or must have known the Mahabharata. Mahabharata is a very important epic in Indian culture and Indian legal system. So that I will discuss in the future. Yeah, what are the sources of Indian legal system? In Indian legal system, first we have Purusharthas. ಕನ್ನಡ ಎಲ್ಲರಿಗೂ ಬರುತ್ತೆ ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೀನಿ. ಪುರುಷಾರ್ಥಗಳನ್ನು ಏನು ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಹಿಂದೂ ಧರ್ಮದಲ್ಲಿ ಧರ್ಮವೆಂಬ ಕಂಬಕ್ಕೆ ಅರ್ಥ ಮತ್ತು ಕಾಮವೆಂಬ ಇವನು ಹಸುಗಳನ್ನು ಕಟ್ಟಿ ಮೋಕ್ಷವೆಂಬ ಹಾಲನ್ನು ಕರೆಯಬೇಕು ಅಂತ. ಅಂದ್ರೆ ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಅಂತಿಮ ಗುರಿ ಸಾಧಿಸಬೇಕಾದ್ರೆ ಪುರುಷಾರ್ಥಗಳನ್ನು ಫಾಲೋ ಮಾಡಬೇಕು ಅಂತ. ನಾನು ಯಾಕೆ ಈ ಮಾತು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳಿ ಅಂದ್ರೆ ಇಂಡಿಯನ್ ಲೀಗಲ್ ಸಿಸ್ಟಮ್ಗೆ ಪುರುಷಾರ್ಥಗಳು ಅನ್ನೋದು ಬಹಳ ಮತ್ತು ಪ್ರಮುಖವಾದ ಪ್ರಭಾವನ ಬೀರಿದಾವೆ ಅಂತ. ದೆನ್ ಧರ್ಮಶಾಸ್ತ್ರ ಮತ್ತು ಧರ್ಮ ಸೂತ್ರಗಳು, ಅದರಲ್ಲಿ ಮನುಸ್ಮೃತಿ ಮತ್ತು ಯಾಜ್ಞವಲ್ಕ ಸ್ಮೃತಿ ಬರ್ತದೆ. ನಾವು ಲೀಗಲ್ ಸಿಸ್ಟಮ್ ಬಗ್ಗೆ ಮಾತ್ರ ನೋಡೋಣ. ಸೋಷಿಯೋ ಎಕನಾಮಿಕ್ ಸಿಸ್ಟಮ್ ಬಗ್ಗೆ ಇದ್ರ ಬಗ್ಗೆ ನಾವು ಅದ್ರ ಬಗ್ಗೆ ಚರ್ಚೆ ಮಾಡೋದು ಬೇಡ, ಯಾಕಂದ್ರೆ ಅದು ಕಾಂಟ್ರಾಡಿಕ್ಟರಿ ಮತ್ತು ಕಾಂಟ್ರವರ್ಸಿ ಆಗುತ್ತೆ. ಮತ್ತು ಮಹಾಭಾರತ ನಾನು ಹೇಳಿದ್ದೀನಿ, ಅದರಲ್ಲಿ ಮಹಾಭಾರತದ ಆಡಳಿತದ ಸಿಸ್ಟಮ್ ಬಗ್ಗೆ ಯಾವಾಗ ನಾವು ಅದರ ಮಹಾಭಾರತದ ವಿಚಾರಗಳನ್ನು ನೋಡಿದಾಗ ಕುಮಾರವ್ಯಾಸರು ಮಹಾಭಾರತ ಬರೆದಾಗ ಅದ್ರ ಬಗ್ಗೆ ಒಂದು ಉಲ್ಲೇಖ ಹೇಳ್ತಾರೆ. ಏನು ಅಂದರೆ, ಮಹಾಭಾರತದಲ್ಲಿ ಏನಿದೆ ಮಾತ್ರ ಅದು ಜಗತ್ತಿನಲ್ಲಿದೆ, ಮಹಾಭಾರತದಲ್ಲಿ ಅದು ಇಲ್ಲ ಅಂದರೆ ಜಗತ್ತಿನಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ. ಅದಕ್ಕೆ ಅವ್ರು ಏನು ಹೇಳ್ತಾರೆ, ಅರಸುಗಳಿಗಿದು ವೀರ, ದ್ವಿಜರಿಗೆ ಪರಮ ವೇದದ ಸಾರ, ಯೋಗೀಶ್ವರ ತತ್ವ ವಿಚಾರ, ಮಂತ್ರಿ ಜನಕ್ಕೆ ಬುದ್ಧಿಗುಣ, ವಿರಹಿಗಳ ಶೃಂಗಾರ, ಅಲಂಕಾರ ಕಾವ್ಯಶಾಸ್ತ್ರಕ್ಕೆ ಗುರುವೆನಲು ರಚಿಸಿದ ಕುಮಾರವ್ಯಾಸ ಭಾರತವ. ನೀವು ಟೆಕ್ನಾಲಜಿಕಲ್ ಇಶ್ಯೂಯಿಂದ ಹಿಡಿದು ಲೀಗಲ್ ಇಶ್ಯೂಗಳು ಏನೇ ಇದ್ರೂ ಕೂಡ ಮಹಾಭಾರತದಲ್ಲಿ ಮಾತ್ರ ಇದೆ. ಅದು ಮಹಾಭಾರತದಲ್ಲಿ ಇಲ್ಲ ಅಂದರೆ ಜಗತ್ತಿನಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ. ಇವನ್ ಟೆಕ್ನಾಲಜಿ ಇರ್ಬೋದು, ಧರ್ಮ ಇರ್ಬೋದು, ಏನೇ ಇರ್ಬೋದು. ಇಲ್ಲಿ ನಾನು ಒಂದು ವಿಚಾರ ಹೇಳಕ್ಕೆ ಇಷ್ಟಪಡ್ತೀನಿ. ನಮ್ಮ ಲೀಗಲ್ ಸಿಸ್ಟಮ್ ಬಗ್ಗೆ ಪಾಂಡವರು 14 ವರ್ಷ ವನವಾಸ ಮಾಡಿರ್ತಾರೆ. ತದನಂತರದಲ್ಲಿ ಧರ್ಮರಾಯ ಹೇಳ್ತಾನೆ ಅರ್ಜುನ್ಗೆ, ಹೋಗು ತಾತ ಅಲ್ಲಿ ಭೀಷ್ಮರು ಶರಶೈಯಲ್ಲಿ ಮಲಗಿದ್ದಾರೆ, ನಾವೆಲ್ಲ ಅರಣ್ಯ ಸುತ್ತಿದ್ದೀವಿ, ಆಡಳಿತದ ಬಗ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಹೋಗಿ ಸ್ವಲ್ಪ ಕೇಳ್ಕೊಂಬ ಅಂತ.
ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಔಟ್ ಆಫ್ ಸ್ಟೇಟ್ ಅವರು ಇದ್ದಾರೆ. ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ ಔಟ್ ಆಫ್ ಸ್ಟೇಟ್ ಅವರು ಇದ್ದಾರೆ.
ಯಾರು
ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್? ಟ್ರೈನಿಂಗ್ ಇರೋರು ಸರ್, ಟೀಚರ್ಸ್ ಔಟ್ ಆಫ್ ಸ್ಟೇಟ್ ಅವರು ಇದ್ದಾರೆ ಸರ್.
ಇರ್ಲಿ
ಕೇರಳ,
ಅದನ್ನ ಹೇಳ್ತೀನಿ. ಸೊ ಅದಕ್ಕೆ ವೆನ್ ಹಿ ವಾಸ್ ಲೈಯಿಂಗ್ ಆನ್ ದಿ arrow bed, Dharmaraya told Arjuna to go and ask how to run administration, and those ideas are incorporated later on in the Kautilyan Arthashastra. In Kautilyan Arthashastra ಅಂದ್ರೆ ನಮಗೆ ಉಪವೇದಗಳು ಅಂತ ನಾವೇನು ಕರಿತೀವಿ, ಗಂಧರ್ವ ವೇದ ಅಂದ್ರೆ ಆಲ್ ಫೈನ್ ಆರ್ಟ್ಸ್, ಆಮೇಲಿಂದ ಗಂಧರ್ವ ವೇದ, ಆಯುರ್ವೇದ ಆಲ್ ಮೆಡಿಸಿನ್ಸ್, ಧನುರ್ವೇದ ಆಲ್ ವಾರ್ ಸಿಸ್ಟಮ್, ಆರ್ಚರಿ ಅಂಡ್ ಎವ್ರಿಥಿಂಗ್, and Arthashastra. These are Upavedas in Indian Vedic or Vedic literature. So because of this, you will find the roots of Kautilyan Arthashastra in Shanti Parva. Kautilya Arthashastrali, he mentions about civil codes and criminal codes. He call it as Dharmastiya code, civil codes, and Kantakashodhana code means criminal codes. So the offender, the accused, must be tried at his native place, not somewhere else, mainly because the local person who is working as a judge is aware of that particular person. So Mahabharata have a greater impact on Indian legal system. Just I want to share with you. Then in Tamil literature, we have Silapadi Garam. So it's the greatest epic in Tamil literature. When some of you see the Kannagiya Kate Tamil film, that says about how the king must administer the law, administer the justice. When he is punishing Kovalan, he errs, he make mistake. Therefore, Kannagi gives Shrapa to burn whole Madurai except children and women. So then we have Tirukkural, Srivallavar. He wrote about couplets like Tirukkural he wrote. It also tells about administration. In Sangam literature, Yattu Togoi Mattu Pattu Pato. These are the references for Indian legal system where we can see the present administration and present legal system in Indian context. Then Kautilya Arthashastra, I need not have to tell you, it is a greater impact on the Indian legal system. How the spy system may be, how the police system must be. And I had an opportunity to read Kautilya Arthashastra. He make a mention that when you find a dead body, one can make out on which position the body has fallen. The reason for death also it is mentioned in Kautilya Arthashastra. That has been published by University of Mysore. If you have an opportunity, you can collect that book and can make a reference. Then Vedic assemblies during that period, after Yajna Yaga, they used to join together and decide numerous legal issues. These are the ancient sources of legal system. When we protect the law will certainly protect us. Ultimately, this is the slogan which we derive from the ancient sources of legal system. Just I want to share with you of Mahabharata as far as law is concerned. Everybody might be aware that the Sabha Parva, where the Draupadi was bought and her sari was stripped. Why all the people were sitting? Everybody was keeping quiet. Nobody raised the voice. Mainly because Duryodhana was the law expert. He made a pleading that when you win anything in the lottery or in the juju, it is become its property. Not only that, it also mentions about the value of a woman during the Mahabharata period. And Vidura is the only minister who opposes it, and Krishna who stops it. So just I want to make a mention that if you are aware of the law, you are protected. ಕಾನೂನು ತಮಗೆ ಗೊತ್ತಿದ್ರೆ ನಿಮಗೆ ಖಂಡಿತವಾಗಿ ಕಾನೂನು ಎಲ್ಲರಿಂದ ನಿಮಗೆ ರಕ್ಷಣೆ ಕೊಡ್ತದೆ ಅನ್ನೋದು ಇವತ್ತಿನ ಪಾಠದ ತಿರುಳು. So next we go medieval period. We borrow numerous programs, numerous legal systems from the Delhi Sultanate period and Mughal period. In each provincial capital, when the Battle of Tehran 1192 made the Islamic dynasty to be established, or India came under the administration of Islam rule. So each provincial capital and had a significant town had a Qazi. Then Qazis conducted trials in front of parties required meticulous legal documentation. So they used to conduct the system. Normally they must have borrowed from the Persian and Arabic literature. The king was the highest court of appeals. The ruler sat in the court called Muslims. The complainants also, both parties must be present in the court. Normally it is followed in Indian context. When any legal proceedings are carried out, both the parties must be present, especially in criminal offense. So next, according to Ibn Battuta, who is the foreign traveler, and here I want to share one information with you. Whoever having knowledge in Kannada, my sincere submission or request you to read Pravasi Kanda India, written by H.L. Nagegowda. It will tell about the Indian socio-economic political system in India that starts from Megasthenes Indica to modern time. There are numerous foreign travelers who traveled to India. They made a mention. And in Ibn Battutta's book, he make a mention of Muhammad bin Tughlaq, monarch of Tughlaq dynasty, heard complaints on Mondays and Thursdays. Normally, we really speak bad about Muhammad bin Tughlaq, Tughlaq Darbar. No teller, no teller, no teller, no this one like that. Asker like. So Muhammad bin Tughlaq brought a lot of reforms. That is secondary. Just I want to make a mention that he also heard the grievances of the employees in grievances of the people during the period. 13th century named Amir Iddad presided over the secular courts during the Sultan's absence. Chief Justice of Sultanate was known as Qazi il Mamlik and also known as Qazi ul Khazar. During the Mughal era, secular judge was known as Mir Adil. He served as judge on the emperor's behalf. We have one dynasty established in Karnataka, Adil Shah dynasty, who built Gol Gumbaz. It is a whispering gallery. It whispers any sound for 14 times. Earlier it was more, now it has been reduced to, is being reduced because of various reasons. Then British period. The British founded Sadar Diwani Adalats, brought common law to India. They were succeeded by institution of high courts. Diwani Adalat, they are the first government courts. That means with written documents and record they bought. And Regulating Act 1773 play important role in the Indian legal system. First time they established the Supreme Court in judicature in Calcutta. Then King George III established Supreme Court in Bombay, Madras on December 26, 1800 and December 8, 1823 respectively. For the first time in India, the Supreme Court came into existence. In 1862, Calcutta High Court was established a formal legal structure abolishing Supreme Court in Calcutta, Madras, Bombay as well as Sadar Adalats in presidency states. Normally, one Supreme Court is there for one country. There may be some benches, but in India it is not there. It is only the Delhi is the seat of Supreme Court. Then Indian High Courts Act 1861, thinking the or taking into consideration of the burden, they started establishing the high courts, especially in presidency areas like Bombay Presidency, Calcutta, Madras, and Delhi Presidency. These high courts rose to prominence in their respective regions, handling appeals as well as original jurisdiction matters. Government of India Act 1990 legislation implemented judicial reforms, notably the separation of judiciary from the government power. Earlier, what used to happen, the revenue collectors or the deputy commissioner, they used to deliver the judgment they used to give. So now on this act, 1919, they separated the judiciary from the executive. Normally it says that when the three organs of the government, if they two join together, they kill the third one. Normally legislation, executive and judiciary, they must be separate. But if they two join together, the other one will be killed. It is the same. Government of India Act, the statute broadened the powers of duties and provincial national parliament. It created a federal court in India as a Supreme Court with authority over constitutional issues. So slowly the Indian legal system, Indian law system, law making system, executive system, all were evolving. They had some scientific approach to the Indian system, normally borrowed from different countries like France, then America, then Russia. Those aspects have been incorporated in the Indian Constitution later. So hierarchy of law in India. The question arises, who is the supreme in India? Who is the supreme in India? For example, you are working in educational institution, your educational commissioner issue an order, whether it has to be followed or the act passed by the state government is followed or central government act is to be followed or which will prevail? The question arises. For your kind information, in Indian context, it is followed as per the Watson law of hierarchy. Watson is the management scientist and philosopher. He advocated which law prevail over the other or which act prevail over other act. It is As far as Indian context is concerned, the constitution is the supreme. It is supreme law of the land. It is rule book of the whole country. It mentions about fundamental rights and directive principles of state policy, major. As far as legal issues are concerned, there are good number of issues. One is legislature, how legislator has to be constituted, then how election should be conducted, then executive, what are the powers of the executive authority, like President of India is the supreme commander or supreme authority, and whatever is done, it is done, executed in the name of President of India, like that it is there. Then main laws, the laws made by the parliament for whole country. The laws made by the parliament prevail over other laws made by the states. There are two types of laws, one procedure laws and substantive laws. So procedure laws makes about the mechanics, process, how the legal process should be conducted, who has to preside over, how the police have to arrest, and all these things are said. They are called Criminal Procedure Code. Now it is Bharatiya Nagarika Surakshata Sanhita. Then Indian Evidence Act. The procedures, and Civil Procedure Code, especially when the court is conducted, as far as civil matters is concerned, it is conducted as per Civil Procedure Code, and criminal this one issues are conducted as per the Criminal Procedure Code. And Indian Evidence Act is taken for the evidence or to handle or value the offense. So main laws, and here I want to make a mention about the legal issues. We have basic structure document. See, you may not be aware, in the year 1975, Mrs. Indira Gandhi declared emergency. See, as for the political science students know that when the emergency is declared, the fundamental rights get suspended and nobody can approach the police station for having suspended the fundamental rights. In that fundamental right, right to life is an important right. What happened? Some of the police authorities at the gunpoint of the rich people in their particular area, they looted the common people. That if they are not going to give the money, they are going to shoot it. So this was the situation during the year 1975 when the emergency was declared. So after that, the amendment was done and basic structure document was created. Whatever it may be, though the emergency is declared, the right to life will not be suspended. They have every right to approach the court and protect their life. In the basic structure document, the central government cannot make the laws as per their whims and fancies. They must follow the basic structure document. I want to share one of the important case which is relevant, that Keshavananda Bharati versus Government of India. What happened? Keshavananda Bharati is a head of one matha. And Government of India was constructing road, national highways. They occupied the land. So he went to the Supreme Court. The Government of India said, we have every right to make the law. We have made the law. They cannot question. Therefore, they have to surrender the law. But the Supreme Court said, you can take over their land by providing proper compensation. Therefore, Keshavananda Bharati versus Government of India case is very important and landmark case while studying the Indian legal system. What I mean to say is, the Government of India also cannot make the laws as per their whims and fancies. Understand? So this is a relevant of the constitution as far as Indian constitution is concerned. So we have substantive laws like Protection of Civil Rights Act, or the Contract Act, Factory Act, Labor Laws, Income Tax Act, all are substantive laws. They mention about the rights and responsibilities and duties of the particular person who is coming under that law. Then state acts. The first constitution, then second one is the central government which can make act. The third one is the state government. ರಾಜ್ಯ ಸರ್ಕಾರಗಳು ಕೂಡ ಕಾನೂನುಗಳನ್ನು ಮಾಡಬಹುದು. State government also can make laws. They have some subjects. In constitution, we have divided the subject into state list, central list, and concurrent list. State and concurrent list, they can make laws, and central list, they can make rules. For example, you have Indian Motor Vehicles Act of 1939, and later on it was made in the 1988. The Karnataka government has made motor vehicle rules of 1989. All registration of licenses, registration of vehicle, issue of licenses, registration of vehicles, tax payment, permit, bus operation, everything is mentioned in the Indian motor vehicle rules. So like that, the state government also must make the laws in compliance with the central government act. The state government cannot make law overriding the central government act. What I mean to say is which one prevail? This prevails. So state act, and next comes the secondary laws. See, in the modern time, see, there is a French Revolution because the king was the meeting point of executive, legislation, and judiciary. When all these organs of the state meet in one point, those persons will become dictators. For example, I want to tell you, IAS officers head numerous institutions. They are the people who make the laws. They are the people who implement the laws, and they are the only people who are going to give you the judgment or justice on the particular rules and regulations. This must be avoided. So, unfortunately, delegated legislation, it is called, all the organs of the government are meeting with the authorities. For example, the commissioner can make the laws, he can implement, he can give the judgment, but later on, whatever decision, whatever laws he made, he cannot make the law against the constitutional provisions, against the state act, against the central government act. Whatever he makes within the purview of the delegated powers. So what I mean to say is, when the question comes, you are implementing the rules and regulations, you have to keep it in mind that the constitution prevail over all other acts. Then comes the central government and state government and delegated legislations. Then the laws are also the judicial decisions, judgments given by the Supreme Court and High Courts are also considered as law. See, they are called ratio decidendi. One case decided, in the same version, the decision can be taken. Therefore, many of the legal cases, we make citations. Under so and so act and again so and so, this has been taken. Therefore, we plead on behalf of this before the judge that the case must be taken or decided like this. So therefore, Supreme Court has the Supreme Court decisions are taken into consideration as the important law. But the question arises, when one executive authority like your commissioner take one decision, whether the same can be applied to other cases? Certainly not, because it is only executive decision. It is not legal decision. The Supreme Court decision is the decision. Even district courts decisions cannot be cited. Therefore, all the citations are from the Supreme Court and High Court. That whenever you taking the decision, you please keep these things in mind as far the Indian legal system is concerned. Then government orders. Then comes government orders, government notifications issues, cabinet decisions are taken. Then in government organizations like KSRTC or Finance Corporation or universities, your board decisions, the boards or syndicates, they make the laws because they are quasi-legislative authorities. They make the laws. They will give the laws to the Vice Chancellor to implement. And the next comes the principal to implement the orders of the or circulars, whatever it may be. So whatever it may be, any laws made must not go against or contrary to the Constitution of India. So then system courts in India, then we have Supreme Court in India, then high state level we have high courts, and district and subordinates level, district courts are there. Then in cities we have metropolitan courts. Then we have subordinate courts at taluka level also and tribunals. So High Court has the power to punish contempt, Article 129. It is original jurisdiction. Normally, the Supreme Court don't have little bit, but what are the original jurisdictions? All cases from one village, they cannot go and file immediately before the Supreme Court. First, they have to, it is mentioned that they have to file a case in the lowest jurisdiction. They have, if the case is in a particular village, they have to file before the taluka magistrate or JMFC court. Then comes, if it goes to appeal, all criminal cases are filed at the district or session courts. So like that, any dispute between state and state, center and state, the Supreme Court has original jurisdiction to try the case. Then highest court of appeal, whatever decisions are taken, and that they can go up to the Supreme Court. Supreme Court is the final court. Then thereafter there is no other court to try the case. So first you have writ petition, then appeal, then SLP, special leave petition is there, and all these things can be exhausted in the Supreme Court. Then writ jurisdictions. We have special powers given to the courts. They are writ petitions, writ of mandamus, writ of habeas corpus, writ of certiorari, writ of quo warranto. 5 writs are there. Habeas corpus means normally what happens, police arrest a person, but they will not show that he has been arrested. So what happens, they can file a case before the High Court to produce that particular person. That is called habeas corpus. Like that, numerous writ petitions can be filed in the Supreme Court, and these are the and whatever decision is taken in the Supreme Court must be followed by other courts. Then High Court has power to punish contempt, original jurisdiction, and when there is a dispute between the state and the government and the state, like that, district and district, the courts are there. Then you have the High Court, you have appellate jurisdiction, original jurisdiction, like that. Then the revisional jurisdiction is also there on civil procedure and criminal procedure code. Then administrative jurisdiction or subordinate court. Whatever decision, whatever circulars issued, the subordinate courts must follow. This is the Indian legal system as far the state level is concerned. We have district court. District courts of civil nature. They are called the district court. Then assistant district court or senior civil judge. Then munsif or junior courts. Municipal courts are third level, that they are taluka level. And after that we have second level. Then district judge, it is this one. And life imprisonment, death penalty cannot be given by the lower court. It is only the district court which can give. And that has to be ratified by the High Court. No other court can give death punishment or this one, as far the district court is concerned. This is of a civil nature. Then comes a criminal nature. The criminal courts are called session courts. So they have session judges, additional session judges, assistant session judges, then chief judicial magistrate, next level, judicial magistrate first class, and judicial magistrate second class. See, in Indian Penal Code, now it is Bharatiya Nyaya Sanhita from July 2025. The IPC has been changed as Bharatiya Nagarika Sanhita Lai. So that get changed. They have some delegated powers. They cannot try all the cases. They have delegated powers. Based on that, they have to try the case. This is the criminal case. Then revenue courts. The Tahsildar is also heading the courts. He is also going to give the judgment on especially land disputes and the assaults. Normally it go to the IPC, go to the judiciary court, but it will go to the police station. The police have to file a case and all that. Then I'll cover next this one. Then regional commissioners and the deputy commissioner or regional commissioners are also the judges, especially issues relating to the orders passed by the deputy commissioner and election disputes. Everything is taken care by the revenue commissioners or regional commissioner. Revenue commissioner sitting in the Bangalore, capital city. Then regional commissioner, every region. We have 4 to 5 regions. One region will have a regional commissioner. He will take care of that. Deputy commissioner, as you know, he is the head of the district. He will take care of land grant, and he is the appellate authority under Senior Citizen Act, and his appellate authority under Right to Information Act, and he is appellate authority of numerous acts. Any decision taken by the assistant commissioner or subdivisional magistrate, they can file appeal before the deputy commissioner. Then the tribunals. For different works, the tribunals are conducted. Earlier, they were land tribunals. See, in the year 1972, Karnataka passed the Land Tenancy Act. The major issue of that act is tiller is the owner of the land. The owner was earlier, the owner was different, the tiller was different. He used to collect every year the product. Then just they have to jeeta like. After 1972, the land was the act was passed, Land Tenancy Act, and tribunals were constituted at each talukas to decide who is the owner of the land, and ultimately they took the decision. Like that, tribunals, and not only tribunals can be constituted, even water disputes also. We have Kaveri water dispute tribunals, and when there is a dispute between the state and center as far as finance sharing, tax sharing, there are tribunals conducted. Then there are numerous commissions also conducted. On that, they can go and plead the before. Tribunals are also the part of legal system in India. So then executive magistrate. See, judiciary is different and executive, like Tahsildar, Assistant Commissioner and Deputy Commissioner, they are also given the power of judicial system. So they declare 144 of Indian Penal Code. That you must have heard 144, declared 144 or curfew life. That is declared by the Deputy Commissioner and also by the Tahsildar and Assistant Commissioner. They will declare the judicial, they exercise the judicial power by declaring the 144, and law and order maintenance, everything is there as far as the executive magistrates are concerned. This is also part of Indian legal system. Tahsildars, assistant commissioners and deputy commissioners, they form part of the executive magistrate. Then what one should know, when you get a phone call from the police station. It's a major issue. When the police call a person, everybody get panic. See, because the nature of police working is like that. So if you receive a phone call from the police, don't panic, never pay money over phone. Politely ask for the caller's name, rank and specific police station, then inform them that will cooperate but require formal written notice before appearing. So anybody, any police station, give you a call that you come and come to the police station, but please request them to give a letter. Sir, under what circumstances I must come? You please issue me a letter. Then I will come and talk to you. See what happens in the name of police. Nowadays, cyber crimes have come. They are making digital arrest, isn't it? So digital arrest they are doing. That means they give you a call that you are under digital arrest, and they will issue directions to keep the phone ready and give you money, and they watch your movement and everything. Then what one has to do is verify the call from which it has come. And scams, as I told you, many scammers pose as police officers to demand money, intimidate victim, digital arrest. Real police do not demand financial details, OTP or money over call. I want to share one information with you. Have you heard the village name called Jamatara? Jamatara, a village. It is between West Bengal and Jharkhand.
It is in Jharkhand, sir. Yeah, it is in
Jharkhand, but
Jharkhand.
it is the border of West Bengal and Jharkhand. Jharkhand, the people in that village all are running in very luxurious cars. Their main job is to cheat the people through this system. So Jamtara is a village. It is very difficult for the police to arrest them because they purchase 1,000 together SIM card, and the moment the business is over, they switch it off. They destroy. Jamtara is known for cheating the people. So what happens? And they will also call you, sir. You have a parcel in your name, and we are bringing you to your house. How they cheat you? Then what that parcel contains the ganja, and they say that it contains ganja, and therefore we are going to arrest you. So For your kind information, anybody asks you that you have a parcel and we are going to give it to you, please ensure that whether you have order for that particular parcel or not. If not ordered, please don't respond to them. So it is my sincere and that how to protect yourself from the cyber crimes like that. So verify independently, disconnect the call and do not call the number back immediately. Look up the office, contact details for your local police station, the district police, Bangalore, you can do it. Then you have legal rights. See, one recently a case has happened. Police cannot arrest any individual if the punishment is less than 7 years. What they can do is they can ask you under section 141 or 41 of the act to give you the statement. You go to the police station, give in writing that this is my statement. That's all. They have to record the statement. So then you know your legal rights. Or for legal written notice, law dictates that police generally must summon you to the police station via from a police this one notice, such as section 35 of Bharatiya Nyaya Surakshata Sanhita, that is Criminal Procedure Code, that is section 41A. Ask the caller to send the notice detailing the case number, your role, and the date and time required. See, in recent time, what happened? One bank officer had lent a loan to a particular industrialist. They were caught by the economic fraud, and this person was called by the police station, and he received the notice. He was panicked, and somebody else told him that it is very serious offense. You immediately go and all. Then I advised him, first let us see what is that. Then internet we browsed, we collected the data. He was a witness. He was not accused. So when you are called as a witness, your position is different. When you are called as accused, your position is different. Please ensure that under what circumstances, as what status you have been called to the police station. So now special protections, if you are a woman or a child or a senior citizen over 65 years, the police cannot compel you to come to the police station. They are required to record your statement at your residence. If a woman and male police constable cannot come to your house for women and ask you to come to the police station. It is only the women police constable who has to come to your house and tell that this is a notice and you are requested to come to the police station. Like that, you must go to the station. And as far as possible, don't go alone. See, it is system. We can't do anything. The police will make you, if you go as accused, they will make your life miserable. So they use different type of getting the information and all. So never visit a police station alone regarding dispute on an investigation. Always bring a trusted family member, friend, or legal advocate. It may not be possible for you to take the services of advocate immediately. You take your friend along with you. At least he will send a message or pass on the message to particular person that you are in this one. Consult a lawyer. He is highly recommended. It is highly recommended to speak with a criminal defense lawyer before appearing for the questioning. I want to share with you 3 things cannot be questioned in the world. What are those things? Nobody, even Supreme Court also cannot question it. What are those? A suspect of a police officer, you cannot question. A police officer can suspect anybody. You cannot question it. It's only a suspect. See what happens. See, one murder happens and that particular place, nobody was there. How they have to find it out? Some person, passerby, was going there. Then he saw that and police caught him, sir, and brought him to the police station. Then he said, "Arey, in what way I am concerned? I am not at all involved. I don't know anything." Yes. They start questioning, why did you come there? From where you were coming? What is your place? Do you know that particular person? Then anybody, his relative know him. What color he was wearing? All these things, questions are therefore. Nobody can question the suspect of a police officer in the world. The second one is estimation of an engineer. If you are constructing a house, an engineer will give you the estimation. You cannot question it. Why he made that one? It's only estimation. If you are interested to accept it, accept it. Otherwise, don't accept it. So the third one is the discretion of a judge. It is discretion. You cannot question it. Sometimes what happens, disciplinary authorities, when as far as the disciplinary action is concerned, when government employee is charge sheeted, the disciplinary authority pass the order. You cannot question it. Why did you pass the order like that? It is his discretion. If you are affected by the order, you can go to the appellate authority or revision authority or court. So under such circumstances, you cannot question or you cannot argue with the police. You just go to the police station politely and tell him. They are also asked to behave properly and politely with the citizens of the country. And the police stations must be public friendly. They are not, they must not create terror among the people. So my sincere advice, and as far in Indian legal system is concerned, if the police ask you to come to the police station, go along with the friend or anybody. Then what should one do if they receive notices and summons? Police calling is different. Issuing notices and summons are different. Summons are issued for the civil nature offences. So, for example, if you have anybody has given a check, it has been bounced, they will issue the summons. They will issue the this one notices that you have this one and we are going to do it. You come and appear before the court. So, if you receive a summons or notice appear before the police at a police station, you must never ignore it. Immediately contact the criminal defense lawyer, review the document carefully to determine are being called as a suspect or a witness and fully cooperate with while strictly protecting your fundamental rights. They cannot immediately enter into they cannot beat because everywhere CCTV cameras are there. You tell them the truth, you share the truth. Then when you receive a court summons, first priority to read it immediately, what it is. It dictate, then why you are being called, specify the strict deadline for your response. They will tell you, take notice that you are asked to appear before the judge on such and such date. If you do not appear, the action will be taken accordingly. So missing the deadline, then failing to appear can lead to severe penalties, then including arrest warrants and default judgments against you. So if you do not honor the court summons or notices, the judgment go against you. If not at a fault, also you will be put to the harassment. Therefore, respect the judiciary. Any notices, go. If you are not there, immediately go and stand before the judge with folded hands and tell him that this is the situation. Next time I am going to bring my advocate. A warrant case. So summons is for civil and warrant is for criminal. So warrant case related to serious offences, while summons cases are related to comparatively less serious crime. In a summons case, summon to be issued to the accused. In a warrant case, warrant of arrest is normally issued for the arrest of the accused. Warrants normally, the police cannot issue the warrant. It is the judges. The police have to take the permission in the form of warrant to arrest anybody. So this is to enlighten about the difference between summons, notices, and warrants. So now we come to substantive laws. We were discussing about the laws, and I was telling you about the Jamtara issues. The information technology is a revolutionary scientific invention, brought a lot of changes in the world. So the father of the Microsoft, all you aware, Mr. Bill Gates, he visited India in the year 2005. Then he made 4 statements. What are those statements? The computer will bulldoze all the fields. If you do not have the computer application, the field will die. Therefore, what you see is nowadays the astrologer who come on the TV, they will open their laptop and predict Faladarshana, the Falaprashna, like that they will tell you. Even the Jyotish is also using, and the field which do not use the computers will die automatically. So therefore, you will see in the judicial system, we can have the video conferencing. We need not have to physically appear before the judge and plead the case. In High Court, I can plead my case by sitting at my home. Only thing we have to have the connectivity and all. then we can do that. So number one, computer will bulldoze all the field. My sincere advice, all of you are aware of the computer knowledge, information I feed. If you are not, my sincere advice is please learn the computer, usage of the computer. It is going to help you a lot. So if you don't know, I worked as an information technology head in BMTC for more than 15 years. I used to tell my employees to spoil the computers. I am here to get it ready. So they started, senior people were there, they started with playing solitaire game on the computer, then they started. My sincere advice is learn the computer. The second one is the service sector will prevail over production sector. So therefore, we'll see hospitals, insurance, hotels, the event management, like that. Then there will be emergence of middlemen and brokers. For anything, there will be brokers and middlemen. Even if you go to RTO office, you go to government office, there are agents. Whether we want it or not, that will come. And the last one is India will emerge as superpower because of its population. Its weakness become its strength. Like that it has happened. So information technology is the product of computerization. So information technology has come into existence in the year 2000, and one must know the importance of the information technology. So it's always primary legislator governing it. It governs the cyber crimes, electronic records, digital transactions, provides legal validity to electronic documents. Earlier, when we were sending the notices, we used to send physically. Now, not necessary. Even WhatsApp text message is sufficient to take note that the particular person has received the information. Digital transactions provide legal validity to electronic documents. Digital signature facilitates e-commerce and outlines penalties for cyber offenses ranging from data breaches and hacking to cyber terrorism. See, nowadays we talk about the Middle East war and oil crisis. Believe it or not, nowadays the data is more than oil. For example, I want to tell you, if you create a database, suppose we have 68 professors attending this classroom. If you take their phone number and I share with the sales agent, what are your requirements? The professor require, what are their teaching this one and their life and all. That will, the people who create this data, they will sell to the big companies. And therefore you receive the fraud calls that you take this one, we are doing this one, including share marketing also. So the core objective of the Information Technology Act is legal recognition, validate electronic contract, digital signature, e-filing of documents with government agencies. Nowadays, you may be aware that e-Khata preparation in Karnataka, you do not have to go to the corporation. You just file on online, and later on you go and submit the physical document to the office, they will create. And timeline has been given, that is Sakala scheme. Sakala, this one has been given. I am going to cover next time this one also. It is legal recognition. Anything you do online, it is recognized legally. Cyber security and enforcement. It establishes legal framework to penalize cyber offenses and defines punishments. So it is say under this act, the punishment is given for the persons who violate the Provisions Act. Nobody can take your individual or personal information to share with anybody. And I am going to cover next this one also. Then intermediary protection provides conditional safe harbor protection of digital intermediaries such as internet services provide social media platforms if they adhere to prescribed due diligence and guidelines. See, you have Instagrams and WhatsApp, social media, YouTube, what not. So they have some framework. You cannot telecast or you cannot post the illegal things. This one advocating illegal things and all. The information technology prevents it, especially when in Kashmir when 370 was declared, all the internet connectivity was blocked. So recently I heard that their telecoms are have been blocked for NEET examination of 21st of this month. That is secondary. What I mean to say, Information Act, Technology Act, sometimes make them to in the interest of country that will prevent. But later on, Supreme Court said that you cannot disconnect the internet connectivity. you can cut some this one, but you cannot deny the connectivity. Let them be contacted like that. Then keep sections and provisions of Information Technology Act. Gives electronic records the same legal status as paper. Lay out civil liabilities, penalties, compensation for unauthorized access and system damage. See, viruses are created. For your kind information, when the software is written, there are good number of companies to write viruses because the business must survive. Therefore, the big companies give money, invest money to write viruses. They only this one create the viruses, and they only find the solutions for that. It is a business. We can't do anything, but it is there. See, hacking and all these things have been protected, but that law prevents it. That must not be misused. Criminalizes computer-related offenses like hacking, identity theft, spreading computer viruses. I want to share one example with you. My friend sent me one email. He was a good friend of mine. So Mr. So and so, I'm very much in financial problem. I request you to send 20,000 rupees to the account and all. I sent him and I phoned him. You asked me to send. Oh, I don't know. I didn't send you the message. Then later on, I came to know that message has been hacked. The email has been hacked and he sent the message like that this happened. These are the types of cyber crimes happening. Then section 66 and 60C and D punishes identity of theft, cheating and personalization. So punishment is there. Then 67 criminal publishing, transmitting of absence material and child sexual abuse material in electronic form. Normally what happens, some miscreants blackmail the women and children. They will they telecast the message and all. So like that has been prevented. If you go to the police station and tell them that, they file a complaint, that they will be arrested. Then empowers central and state government to intercept, decrypt, block public access online information website for reasons of national security and public order. So this is all the central government has been given power. And recently, some of the allegations were that Cockroach Janata Party's website and everything has been hacked. It is none of our business. But the thing is, there is a provision under the law as far as the information technology is concerned. Grant safe harbor intermediaries, protecting them from liabilities of third-party content provided they observe necessary due diligence. The Act says, when you make use of the information technology, you must act diligently. So, Bharatiya Nyaya Samhita, BNS, Indian Penal Code, and cyber crimes. See, there is no separate cyber crime act. It is mentioned in Indian Penal Code. Bharatiya Nyaya Samhita drastically modernized Indian criminal law. It was earlier known as Indian Penal Code, passed in the year 1860, and there is some modifications have been done. So digital offenses as equivalent to physical crime. See, earlier it was not there before coming of Bharatiya Nyaya Sanhita, classifying large-scale cyber operations as organized crime. It works in tandem with information technology, as I told you, making it easier to prosecute modern digital threats. See, nowadays, good number of frauds are taking place in the name of share market, in the name of online shopping, and you receive messages from the international, some people that my ancestors have let me so many million pound and your name appeared there. I want to share that money with you. Please be in contact and contact so and so liar and all. So that also a sort of this one, and that covers under this. But unfortunately, what happens? They do not disclose you their identity. They operate in somebody else's name. So like that, the doing this is offense under the Indian Penal Code. It is not mentioned in the Information Technology Act. It is in the Cybercrime Indian Penal Code or Bharatiya Nyaya Samhita. So section 111 for first time cyber crimes committed by a syndicate, group of persons, individuals acting together with a common intention to seek financial gain are treated as organized crime. This covers ransomware, collectives, rogue call centers, large-scale phishing, having punishments extending up to life imprisonment and death. Earlier, it was not there. If they do like that, especially when they fraud or make digital arrest, they will fraud money like anything. So therefore, this has come. They can be punished with death or life imprisonment. It's introduced in the year Bharatiya Nyaya Sanhita in the year 2025. Section 112. Petty organized crime targets small-scale fundraising, drinks, online scams, and mule bank. Mule bank fake. In the name of somebody else, they create the bank and they say that you give this money. And what they do is you deposit this money. We are going to give you this amount, and we are make your money double and all these things. So they do it. Even in some of the states, online rummy game are being played. That's also some states have banned them. And even the social media has been banned in Australia and in some Telangana state or Andhra Pradesh state like that they are doing. And even Karnataka government is also thinking of banning the social media used by the students. So Bharat and Indian Penal Code provisions relating to cyber crimes. Section 318, cheating and dishonesty, applies to the frauds conducted via electronic means. It's UPI fraud, phishing links, and online investment. And what they do is they ask you to share OTP, and they will give you a call. Your bank account is going to end on such and such date. If you do not update your KYC, know your client. KYC, know your client. If you do not update, you are going to close the bank. If you share the OTP and all, it will all go. This also punishable under the law. See, it is called golden hour. Immediately after you come to know that this has been happened, kindly talk to the CN police station. In every taluka, there is a CN police station, or even district there is CN police station. Cyber, economic, and narcotics police station. They are specifically for the criminal offenses, then the economic offenses and narcotics. Then cheating by impersonation punishes individual who create fake profiles, fake social medias, accounts, Instagram and LinkedIn, bogus website to cheat others. It is punishable. Then cyber stalking, harassment. Stalking means not harassment. Then applies when someone threatens another person that if you are not going to do this, we are going to arrest you and all. That's also punishable. Electronic forgery and data theft. As I told you, data is equivalent to oil. The whatever important the crude oil is there, the same important data is also having. Then electronic forgery then deals with offenses like email spoofing, altering email, creating fake digital documents, bogus websites, especially when they go for the real estate business, they do all those things. Then even recently I heard one fellow created the checking inspector, traveling ticket inspector in Delhi. Then he made an example, showed the people that how they can cheat it like that. So like that happens. So forgery then covers theft and dishonest possession of mobile phones, computer hardware, and unauthorized data. Even the stealing of the mobile is also coming under Indian Penal Code. Then 294 prohibits publication of transmission of absence material, including transmission via electronic and digital forms. Voyeurism, especially the sexual photos and video clips and all, just threatening or blackmailing the ladies, it's a punishable offense. Immediately they will be arrested and put behind the bars. And they can be arrested without, there are two types of arrest, cognizable and non-cognizable arrests. Cognizable offenses.
ಹೇಳಲಿಲ್ಲ ನಂಗೆ ಮಾಡ್ಬಿಟ್ಟೆ.
Hello?
ಬರಲ್ವಾ ಮತ್ತೆ
Hello. Yes, like that. There are some for arresting the people, they have to take.
more copy.
Police have power to arrest. Police have powers to arrest without warrant in some circumstances. So income tax. Now you come to the Income Tax Act. Because you earn money, you have to pay the income tax. Recently in the year 2025-26, if your income is less than 12,75,000, you need not have to pay the income tax. And income tax, no, it is very difficult to define what is income. And it is only somebody is the mic, please switch off the mic. So defining income is very difficult task. So some say that when we were students, they were telling, winking at a beautiful girl in the dark room, or catching the black cat in the dark, the income. You must have heard Haji Mastan. Haji Mastan is known down in Mumbai during 1970 to 80. Then he used to pay the tax. Income tax, he used to go to the income tax office and pay the tax. Then they asked, the tax authorities don't ask you the source from where you earn the income. It may be from robbery also. They will receive. You are paying the tax. If your tax is more than limited, they will accept the tax. But then the question arises, are you not authorizing the illegal activities? No. It is somebody else, the police department or FERA Act, which is going to take action. As far as income is concerned, income tax authorities, they will not ask you the source of income. They will only tell you, you have earned this much income, you pay the tax. That's all. The one question arises. When you go to the temple, Aarti is performed, right? In the Kumbhakonam, Aarti, you will say Aarti Tattege. You will get some money to the this one, no? Aarti Tatte. That is also taxable. It was held. Kumbhakonam temple versus Commissioner of Income Tax. The Supreme Court said that yes, it is also taxable because it is income. If it exceeds more than, that means you have to give the tax on the profit earned. You consider it as income and show some expenditure, then total earned income, you have to pay the tax. Then another example I want to share with you is C. Rajagopalachari, known philosopher. Then he used to go for delivering the lecture. The income tax authorities went and caught him that you have to pay the tax. Then he said, "Arey, it is my honorary work. I am delivering the lecture. Then why you are questioning it?" No, Supreme Court says once you take the money, it is income. You have to pay the tax. However, up to certain limits, if you earn more than 10,000 rupees, it is exempted. After that, you have to pay the tax. So like that, income tax is defining income is very difficult task. What I mean to say is I just shared 3 examples, but unfortunately or fortunately you call it, be proud of yourself. Salaried people are the only people who pay the income tax honestly. Nobody will pay the income tax honestly. Some traders and some business people, they have 3 types of accounts. One is Rama, then another is Krishna, another is Govinda. Rama is known to the government, Krishna is known to the employee, the owner, and Govinda is not known to owner himself. Nobody knows where it goes, where comes and down. See, like that, income tax also is applicable to the professors who are working, recently selected or not. If your income exceeds more than 12 lakhs in a year, 75,000 is a standard deduction for your livelihood. So they say that the income tax 75,000 for living your life, 75,000 is exempted. After 75,000 12 lakhs, these are the slabs. And individual and companies are also equally treated. They are assessees. They will assess the income. The question arises, sir, the companies they earn, they don't show the income. No, they show the income and also they show the expenditure, which is more than the income. So like that, so it is Income Tax Act. Everybody must know. I hope this is going to help you to understand or to assess your income. Earlier, it was not like that. There were some provisions under ATCC, like your PF, KJID, then interest paid on on house building loan. All these things were there. Now it has been abolished. 12 lakhs. After 12 lakhs, you have to pay this much slab. Total to 40, this one after 12 lakhs, 4 to 18 lakhs, 8 lakhs, you have to pay 5% of the total income earned. So like that it goes. Income tax, it is earlier also there. The Kautilya says in his Arthashastra, the collection of the tax must be the relationship of flower and the bee. See, what the bee does is, it will come to the flower, make a survey, help for the pollination, take the nectar and go. Like that, when you tax the people must happy to pay. You must not exploit the people to pay the tax. When we see the historical this event, some of the people, when they issue more taxes, put more taxes on the people start migrating. So that also been said in the Kautilyan Arthashastra, and unfortunately nowadays it's also used for corruption. When you take the money, you have the system. So it is, don't take it as a reason, part of this lecture, just I want to share. So what is section 87A? An assessee being, all are assessees. We are all assessees. Assessor is income tax. We are assessees. Individual, companies, everybody. Being an individual resident in India whose total income doesn't exceed 500,000 or 5 lakhs shall be entitled to deduction from income tax following deductions under chapter 80C. His total income with which he is chargeable for any assessment year and amount equal to 100% of such income tax amount to 12,500 rupees, whichever is less. It is section said about the assessing the income tax. Then Indian Penal Code. See, the question arises, sir, we see good number of illegal things happening in front of us, but we can't do anything. But however, in Indian Penal Code or Bharatiya Nyaya Sanhita, if anybody affecting the public health, safety and convenience and decency and morals is punishable under the Indian Penal Code. So public nuisance means what? Nyaya Sanhita, public nuisance is defined as any act or illegal omission that causes common injury, danger, or annoyance to the public or to people living or occupying property in the vicinity. So, an example, when you come to bus stand, smoking is prohibited in the bus stand. And in KSRTC recently we say, the KSRTC people find a good number of people. It ran in lakhs together. No, smoking is not allowed. Like that, any nuisance created in this particular, the Act says, Section 268 says, it is punishable, public nuisance, and definitions also it says, negligent act like to spread infection of diseases and dangers to life. Anybody, see what happens, I heard once, one fellow who was suffering from AIDS, he thought that let others also suffer from AIDS. He put some blood and took this one pin, started piercing others. Let them also have the AIDS like. So these nuisance are prohibited under the Indian Penal Code. Then malignant act likely to spread infection diseases are dangerous to life. Then disobedience of quarantine rule. When Corona came, they asked to be in the home and all. If you are not obey, they are going to punish you. Adulteration of food and drink. And when the people are selling adulterated drink and this one, I want to share with you, there is the tea is prepared, especially in public places, and I feel in trains also. There is a coolant. It looks like milk. It is made up of caustic soda and edible oil. If you make caustic soda, mix caustic soda and edible oil in certain proportion, it will become milk. It is used as a coolant in industries. What they do is they prepare the milk. It is called synthetic milk. In Delhi, it is sold in the open market. Synthetic milk. The original milk is 60 rupees per liter. This milk is 20 rupees per liter. What they do is they put tea powder and coffee powder, give it to the tea. 4 rupees, 5 rupees, 10 rupees tea. My sincere, this is happening, synthetic, but nobody knows. Then how they can control? They will, this is happening. So as far as possible, okay, the question arises how to identify it. If that tea do not have the layer, cream layer, then it is synthetic milk and it will not become curd. Simple. Two things one must keep in mind. That also is prohibited under the Indian Penal Code. So sale of noxious food and drink, the drugs and all, adulteration of drugs, then sale of adulterated drugs, different drugs preparation, boiling water, when drinking water, now it is all tapped, no problem. But earlier tanks were there, wells were there. They used to spoil during that period that have come, making atmosphere is spreading some smoke which is going to affect the health of the people or convenience of the people. That's a nuisance. Rash driving. Normally we see that young boys with big noise, they drive the two-wheeler and all. If you come to know, they can file a police complaint or inform the police. You no need to file a complaint and inform that this number is doing all these things. But they drive in such a fast that it is very difficult for me also to note down the number. So this is also nuisance. Rash and navigation vessel, especially it is for the water. This one. Yeah, exhibition of false light and mark. See, one must not misguide the common public when they are going unnecessarily giving deviation and all that too. Conveying person by water for hire on unsafe overloaded vessel. That you must not carry, especially in the boats while ferrying or crossing this one. You must not carry. And negligent with respect to poisonous substance. Usage of the sprayer and all, that one must not do. Negligent act must not do. Then negligent conduct with respect to machinery, especially that comes in industries. So these are all the provisions under the Indian Penal Code. Yeah, the code by mischief. What is the mischief? It is also said. And I feel it is time for you to this one. And in the next session, I'm going to cover other acts which are substantive laws, which are relevant for our day-to-day life. So thank you very much for having listened to me patiently. And if you have any doubts, you please give in writing, or if you have time, you can share with me. I will share my email also with you. And I'm practicing advocate in Mysore. If anybody is in Mysore, if you have any issues relating to your service matters and all, you can contact me. And if we thank you very much. And I feel it is my pride to be with you, because the teachers are the elite persons, elite class in the society. They can only change the society, nobody else. Thank you very much.
Thank you, sir.
Dear participants, do you have any
Thank you,
queries?
sir.
Please go ahead. Anyhow, sir will engage one more session.
Yeah.
And by the time also you can raise your queries. Okay. Now I request, okay. That's all.
One or two questions.
One or two questions. If you have any doubts or queries.
Professor, good afternoon. I would like to add, in the beginning of lecture, you started with Kannegi story. Hello?
Hmm.
Before Kannegi, there is one